Shear and Ms. Woodward, if you would both activate your audio and videos, please. And if you would both raise your right hands. Testimony in this case will be the truth, whole truth, and nothing but the truth.
Mm-hmm. Yes, Your Honor.
Thank you. All right. It looks like, to me, this issue's already been decided.
Yeah.
So,
No.
Ms. Shear, looks like Commissioner Wool signed an order on the 7th of July adding the children's names.
Yeah, I also requested a modification because Alana is not respecting my boundaries at all. She beat me up and assaulted me, and I don't want my kids playing around her kid, and she will not respect that. And she says it's not fair, but she should have thought about that before she beat me up because I will not allow my children to be around any of them ever. And she had cameras pointing towards my home. I don't feel safe. I don't feel comfortable. They need to be respectful and leave me and my family alone. The judge didn't order it a distance that she needs to stay away from us, and I would appreciate if you would do that. Your Honor, the problem is that we are direct neighbors, so we need some kind of thing like distance that she needs to stay away from my children and I.
Right. I understand what your legal issue is, or
And
what
I also want you to know that I'm also here to request a protection order against her mom because she tried to run us over.
I'm sure you're not going to get anywhere unless you only wait until I ask you to speak. All right. The question I have here is, it looks to me like the judge already has reviewed your petition that you filed, pointing all of this out, and decided the only thing he was going to do was add your children to the protection order. And he specifically made a choice not to put a distance restriction in because you are immediate neighbors. I think this issue has been resolved. He filed an amended order adding your children, but he decided not to change or add a distance restriction. He read your petition and decided not to do that. So there's nothing for me to do today in this regard. So you did not get what you asked for as far as a distance restriction. He did say that your children are added to the order. So I can't go back and revisit another judge's decision. Ms. Shear, just address that issue, please.
Can you at least tell me what this order does so that I can understand what this order is doing?
All right, this order directs Ms. Woodward to cause no harm to you and your children. It tells her to have no contact with you or your children. Ms. Woodward is not to go onto your property or the daycare or school of your children. And it makes, Judge Wool made very clear that this order does not exclude Ms. Woodward from being on her own property. And those are restrictions. Now, the complaints you made earlier that you were assaulted, I don't know if that was prior to this order or not, but that's up to law enforcement. That's a crime. They can choose to make an arrest. They can choose to forward it to the prosecuting office. Enforcement of the order is up to the sheriff's office or the police.
The order was because of the assault. That is why I got the protection order.
Right. So you have an order, and whether Ms. is charged or not is not in the process of this order. That's up to the law enforcement. Hold on. We're not going to argue. You're just going to listen. You've asked a question. I'm going to give you some information. So you have an order that tells Ms. Woodward she can't have contact with you. It doesn't matter where you are. She can't have contact. So if you're telling me she's had contact, then the challenge for you is having evidence of that contact, witnesses or video or whatever that you can show to law enforcement to say, look, she's violating. The fact that there's not a distance restriction doesn't mean that the sheriff can't enforce it. They can. If there's proof that Ms. Woodward has had contact with you or your children after the entry of this order, then that's up to the law enforcement and the prosecutor's office to decide whether there's something there they can do to enforce that order. So do you understand that?
So I did call the police after Alana was sitting near my children. And the police said that it doesn't state in the order a distance.
That's correct. It does
They
not.
were confused that she can't be near my kids.
It doesn't say she can't be near them. It says she can't have contact with them. She can't
I
say
don't
anything.
want her. I don't want her near my children, and I have that right as a parent. I want her to stay away from my children.
Thank you, Ms. Shear. We're going to end this on this particular case because the decision has been made. I cannot change another judge's decision. So as to Ms. Woodward, that decision has been made. I see you filed a petition regarding Ms. Paz, and I'll deal with that in a moment. But as to Ms. Woodward, that decision has been made by a judge. The decision says Ms. Woodward is to have no contact with your children. So that means she can't speak with them. She can't touch them. Doesn't tell her she has to be any distance from them. Just says she can't have contact with them or with you. And the judge was very clear about that. And that's the final decision on that.
Well, as a parent, I'm going to say my kids cannot be near her at all.
That's fine. That's fine. You make those parental decisions.
Oh, I am.
Okay. All right. Ms. Woodward, you're all done. Thank you.
What about her having cameras pointed towards my house, Your Honor?
I am not addressing anything regarding Ms. Woodward because Commissioner Wool already addressed the order. I'm not changing it. I don't have the right to do so.
No, but
So-
what about her having cameras pointed against my house? Isn't that illegal
Sure.
and harassment?
Okay. I don't enforce the order. That's up to law enforcement. All right, Ms. Scheer, activate your audio, please. All right. Tina Paz is Ms. Woodward's mother. Is that what I understand?
Yes, Your Honor.
Okay. And you describe one incident in here where you say that she drove around you and some friends over the speed limit in the apartment complex, and you said drove a circle around, looks like 3 of you. When did this occur?
This occurred the other day. This occurred on the day before I went into court the next day to get this order. So it had to have been Thursday night.
Okay. Did she say anything to you?
She came speeding at us, and at first I thought it, like I said in the order, I thought it was my other neighbor because she speeds through the complex. But then she was going towards us, so then I thought it was another girl that lived here that had yelled at my children earlier on. And then when she pulled into Alana's driveway at a speed and parked and got out of the car, I said, "Oh my God, that's Alana's mom." And she said, "Yep, sure is," just like that, and then slammed Alana's door as she was going in.
So,
And yes, my apartment complex has it on video.
okay. And did you call the sheriff and have them look at the video?
The officers came out, but it was nighttime, so no, they did not see the video. But I did call in and let them know that the video was found by the landlord. Whether or
And
not they saw it, I don't know because the officer didn't get back to me.
right. Does Ms. Paz live in the same apartment as her daughter?
Nope,
Does she live in the apartment complex at all?
nope.
Has she ever said or done anything to you otherwise besides this
Yeah,
incident?
she's been rude to me always. Even when I was friends with Alana, she had an attitude towards me for no reason. She's not a very nice lady.
Okay. Well, we can't change how people's
Okay,
behave.
but don't you see how this is becoming an aggressive harassment towards me? Her mom tried to run me over.
Okay, which isn't a crime. So if law enforcement believes there's a crime there, they can charge her.
What they did was they advised me to get a protection order against her so that they could do something.
Right. All right. So has she ever, when was the last time prior to this incident that you had any contact with Ms. Paz?
She's here all the time.
Okay. So every day?
The other day, she's here, yeah, pretty much every day, every couple of days. She's here all the time.
What's the nature of the contact that you have with her at that when she's there?
I don't contact her at all. I have a protection order against her daughter. I haven't spoke to her at all. I didn't speak to her before or after the incident. I have no idea why she did that.
How does
I
she
don't
have
see why this is funny.
Because you
I
keep
don't
talking,
feel safe.
we're not going to get anywhere unless you just listen and answer my questions. What is the nature of her contact with you? What are you asking me to stop?
To be honest, me and Lindsay wanted her 86th off the property because she tried to run us over.
Mhm.
I want a protection order against her at the very least where she can't come near me or my kids again. If I had been holding my 1-year-old child when she drove near me like that, that would have been so scary.
And what makes you think that she did that on purpose?
I know she did it on purpose because she drove a circle around us in a parking lot. I don't think you understand. She drove a small circle around our bodies. We felt the heat on our legs. And then my neighbor talked to Alana, and her mom did that because she was mad that I said my kids couldn't play with with Alana's boyfriend's nephew or brother. And it's my right, the officer said, to not have people around my children. I don't think you understand the brutal assault Alana did, and now her mom did that. I don't feel safe. And you guys aren't really protecting me or ordering anything that my landlord can do.
Well,
Did I have to get ran over before something happens?
tell me what else happened. Has she ever said anything to you? She threatened you. Ms. Paz.
Yes, that was threatening. What she did after I got a protection order against her daughter.
Anything other than the car? Has she said anything to you? She said, I'm going to get you because you got an order against my daughter. Has she said anything like that?
Does it have to come to that? I don't understand what you're saying. She drove
You want
towards
to,
me going 20 or 30 miles an hour.
so the answer is no. She hasn't said anything other than the incident. I'm asking outside of the incident, what else has happened? You have an answer?
No, because I feel like I have to die or be injured really bad before you guys will do something. This is not funny to me. You're sitting there laughing. It is not funny to me. This is me and my family's life. I want Lana and her family to leave me and my family alone. I have lived here for 8 years. She's lived here for a year or two. I am not going to allow her children to play with my children.
This is not
I
about
am
Ms.
not going to allow her to be around my children just because you guys think it's funny. This is a serious matter to me, Your Honor.
Okay. Ms. Shearer, number one, we're not talking about the order with Ms. Woodward because I told you another judge has already decided that. I cannot
They
do
asked
anything.
for a modification. How can you not modify it?
The judge already did the modification, added your children, decided not to add a distance restriction. That decision had.
Can I ask you a question? How do you know he decided that? Because I was told that he was adding my children because he was supposed to be added before, and that I was going to court today about the modification. That is what I was told.
That's not what I see here. I see that he saw your petition and specifically wrote on there, he wrote that Ms. Woodward can be wherever she wishes relative to her property. She can't have contact with you or your children. That was made very clear on his order. I cannot revisit that order.
You mean the first order, not the modification?
No, the modification. So I
I would
cannot.
like to see that because I don't.
Okay, so we're not arguing that. We're talking about Ms. Paz. You want me to issue a no contact order against Ms. Paz. I need some information from you. I understand what you've told me about her circling around you in her vehicle. Has anything else regarding Ms. Paz occurred that makes you believe she is threatening you besides the automobile incident?
That is all I needed to feel unsafe. So
That's
no, that's the only thing that she's done so far. But that
okay.
doesn't mean more won't happen if you do nothing about this.
I understand that.
The officers believed I should get a protection order.
Okay. Sheriffs always say that because then they can stop an investigation. So if there is a video, I strongly suggest that you call the sheriff and ask them to look at the video, because what you're describing is a potential vehicular assault, and that's a crime, a very serious crime. And if they look at the video and are satisfied that in fact that's what occurred, they can forward that to the prosecutor's office for filing of a criminal charge. But if they don't look at it, they can say, yeah, go get a protection order, but nothing really changes. So if there is a video,
I'm still very much going to ask them to get that video, very much so.
well, okay.
But in the meantime, if that is what occurred, don't you think I should get some protection?
So telling people not to commit crimes doesn't mean they didn't commit a crime. So I can order everybody in the world don't commit a crime, but that's not much protection. So if there's a crime been committed, I strongly suggest that you follow up on that.
There was a crime committed. She was driving right for us. We had to move out of the way so she didn't hit us. And then she sped around us in a circle and then flew into the... It's 5 miles per hour here.
Okay. Well, you may want to get a copy of that video, because what you've
I
told
don't
me
know
is,
how to get a copy of that video.
well, you can contact the sheriff's office. You can verify with the apartment complex that in fact there is a video that shows.
Oh,
what
we
Ms.
know there's a video. Lindsay already verified with the manager's husband that there was a video found.
Okay. And did the sheriff see it?
I told you, I called and requested that sheriff that was here that night to call me back, and he has not. And it might be because it was a holiday.
Okay. All right. I don't control the sheriff. I can't order them to do anything. So
I'm going to call that when I'm done here and follow up on that. But I'm just asking you if I can get a protection order for what happened. The more that they get away with, the more they feel like they can get away with.
all right. You need to understand there's a limit to what these orders can do. And you've already found that out on the order regarding Ms. Woodward. Judge has made
Yeah,
a
I
decision.
don't understand why she was able to assault me in front of my children and then be around my children.
I'm not the one who made that decision. That decision has been made. I don't revisit it. So that's what the court's decision was. I suspect it was because she lives next door to you, and the judge was not inclined to force her out of that apartment.
He doesn't have to. I asked for a distance outside that she needed to remain away from us. That's all I asked for. Doesn't matter. I'll just have to enforce it with my children, I guess. That sucks. My kids will have to leave the park if she comes there. I'm so tired of dealing with this situation. I just want them to leave us alone.
Judge's order regarding Ms. Woodward tells her to do that.
But what about the cameras? She's allowed to have them pointed at my home?
Do you have any video that she's taken from the camera or photos?
How would I have that? We don't speak.
Right. So that's a really hard one to enforce. So that's typically why we don't address those issues on protection orders. Because lots of people do things like that, and then they say, well, my camera is just my security camera, and take in other things. So I don't see any basis for me to issue an order regarding that. I am going to issue a temporary protection order against Ms. Paz, telling her to have no contact with you or your children, not to come within 10 feet of you or your children.
What about my boyfriend? He is Aaron that she also drove around.
If he wants an order, he has to file a request for an order. Only one person files a request. There will be a hearing on this issue on the 15th of September, just like this. And Ms. Paz served.
Do I get it from the, do I call the civil department to get the Zoom link and everything?
It will be emailed to you.
Okay.
So hold on just a minute.
Okay. Sorry and thank you. I don't feel safe anymore here.
Well, you need to understand that there are limits to what the court can do to a protection order. And if you understanding, sure, stop. If you stand what those limits are and you think that's not enough protection for me, you may have to make different decisions as a parent and what you're going to do. But there is a limit to what the court can do. So you need to understand that, and it may not meet all your needs. So you may have to make other decisions.
Well, how do we get the officers to understand that in the order against Alana, it states that she can't be near us?
It doesn't state that. It says she can't have contact. So, for example,
I wouldn't want to be around somebody that beat me up.
right, but the court hasn't ordered any distance restriction.
Fortunately, yeah. The officers also have limitations to what they can do. So I feel like there's not a lot of protection here.
If Ms. Woodward yells at you, talks to your children, talks to you, sends you a note, emails you, that's contact. And you can
Okay.
provide evidence of that contact to law enforcement, and they can then enforce the order. But if she's outside and you're outside, there's nothing in the order that tells her she can't be there. But if she says things to you or to your children, that would violate the order. So you do have.
So she cannot speak to us, touch us, anything. She can be near us as long as she doesn't talk to us or touch us.
The order says, correct.
Thank you, Your Honor.
And as pointed out, the issue is going to be when you call police is to have some evidence that she's done that. So either witnesses who will tell them that that's what happened, or a video of it happening, or you telling them that's what happened, and they'll decide whether they believe that's enough evidence to go forward. But that's up to them. That's not part of the order.
Yeah, I just don't think they're understanding the order either. They're very confused with the order themselves. They don't see a distance, so they don't know what to do.
Right. Well, the order is very clear in what it says, and they can decide whether there's evidence of a violation of the order. And that's seemingly, to me, that's what you're really frustrated about, is the inability to have the order enforced and their reluctance to do so. And I can't change that. That's
Well, what if my kids are playing with the neighbor kids, right? This is what happened the other day. I'm sorry, I'm not going to keep dragging this on forever. I just want to know if this is a violation or not. She didn't talk to my kid, but so my kids' friends were saying that they couldn't play with her kid because I don't let my kid be around her kid, right? And she was like, "That's not fair. That's not fair." So then my kid went inside to get away from him.
okay. I'm not sure who said that's not fair.
Alana was saying, "That's not fair. That's not fair." And you know what wasn't fair? What wasn't fair is when she came into my house and beat me up in front of my children. That's what wasn't fair.
Okay. Like I said, she can't contact you or your children. So if you believe she said something to your children, provide that information to law enforcement.
Okay. Thank you. Now, as far as her mom, I'll stop bringing up Alana. Let's finish up on her mom.
And the mother does not live in the same apartment complex or anywhere near that apartment complex. Is that right?
No, she lives further down the road near the RAC park. The regional athletic complex in Lacey. She lives near there.
Thank you.
Mm-hmm.
Do we have service before sheriff's office?
I think it was for an element or adult.
In a second.
Are you issuing that her mom not come on the property or just that she don't be near me?
That she doesn't, same thing, that she can't have contact with you or your children.
Okay, thank you.
And I put a distance restriction in here that she stays 10 feet away from you.
Okay. Yeah, thank you. I appreciate that.
What's that?
The sheriff's, I'm looking right now, but if I need to update it, I can.
Okay.
I'm sorry if I seem argumentative today. I just am tired of dealing with this situation. It's exhausting.
Yeah, I understand that.
Yeah, I'm just tired of it. Just want to live my life in peace is all.
Change the type of
I will, Ryder. I'm trying to finish up with the judge, please. For another minute. We're almost done, honey.
As I said, the next hearing is on the 15th September. Ms. Paz isn't be served. This order can't take effect unless she is served. And
Yeah, I will
I've
have them serve her.
sheriff's office to serve her. So you'll want to stay in touch with Thurston County Sheriff's Office.
Oh yeah, I'll check in to make sure she's been served for sure. So September 15th at 9 a.m.
All right.
Is it at 9 a.m.?
Yes.
Okay. And then as far as the other stuff, it'll be emailed to me or I can get it from the civil department.
We'll send you an email today about what you need to do next.
Okay. Thank you so much. Bye, Your Honor.
All right, 33rd is fourth on session. I will make the case and preside.
Seat, please. Philip Trofibio versus Mariah Stennett, 2502959. Lisa, you out there?
Yeah, I'm here.
Well. Happy birthday.
Thank you.
Just happens to be a big one, too.
Yeah, it does.
Watching the show and somebody said, you know, when you reach 50, you're reasonably certain that your life is half over. So I'll just leave you with that thought as we go on.
Oh, well, thanks. I feel much better about it.
Happy birthday, kid.
Thanks.
All right, Ms. Stennett, your name. This is 2502959. Trofibio versus Stennett. Ma'am, your name?
My name is Mariah Stennett.
Mr. Trofibio, your name, sir?
Philip Trofibio.
All right, ma'am, how did you come with funding?
So I am getting a partial of $2,399 from my MDHS application. And then the September balance of $1,100, I will have September 12th, making a full payment of.
Sir, why don't you give me your breakdown as to how much is owed? I need you to tell me, first of all, how much rent there is to retain possession.
Okay, Your Honor. Currently, the rent would equal $3,300.
It's $1,100 per month?
Yes, sir.
And then are there late fees?
Yes, sir. We discussed this a few meetings ago. They came out to be a total of $700 and you knocked them down to $500.
How many months of rent? How many months of rent?
Three months of rent?
No, I never knocked them down to 500. I don't give $165 a month. I'll give you 50 per month. That's the best I'm going to do.
Yes, sir.
If you,
I think that's what you did. Your Honor.
Well, then that's only 100 because she wouldn't be late for September, rent, right?
Well, she will be on the 12th.
I know, but yeah, I'm going to give you $100 in late fees.
Okay.
And then you have a $55 filing fee. What was your service fee?
$44.95, sir.
All right. So do you have any other out-of-pocket costs?
No, sir.
So she owes you $34.99.95, right?
Yes.
The initial $3,300 did not include any late fees, correct?
Correct, sir.
All right. So here's what I'm going to do. Ma'am, you're going to have all of this by the 12th.
Yes.
All right. Sir, you're going to have to present a judgment. It's going to be judgment after hearing. The writ date in this case will be September the 12th, but you have to bring that up here. Can you come up here and fill out a motion now? I mean, a judgment now?
Yes, sir. I could come up. I could be there in a half hour.
Perfect. Come on up here, Jennifer. Lisa, tell Jennifer or Linda, whoever, that to have him fill that out and to bring it right to me, and I'll sign it if you would, please.
I can hear you, Your Honor.
Okay, so you got that? You understand?
Yeah, you need a judgment after hearing.
Right. 30, and so he's gonna prepare it, and the writ date will be on the 12th.
Okay.
All right, good luck to you, sir. Ma'am, best of luck to you both. Thank you both.
Okay, see you shortly.
Thank you. Angela Marie Rellinger, 214-725-324.
Judge, the victim's on Zoom.
Okay, your name, ma'am?
Angela Marie Rollinger.
And who is the victim?
Angie Marie Renana Contrastato.
Okay. Her mother?
Yes.
Okay, so you were notified. By law, we have to notify you when by law, they're entitled to early discharge half the time. We notify the victim on an assault case when somebody's entitled to early discharge. So any case that involves a victim like that. So do you have any objection to her being discharged early?
No objection, Your Honor.
You assaulted your mother?
Yes, it was dropped down to a misdemeanor. I did the probation. There was a 10-month period. And the halfway mark was March for August.
You two been talking? I see I made no assaultive, abusive, or intimidating behavior, not a no contact provision.
Yes, we made up and I actually moved back in with her.
Raise your right hand. You solemnly swear or affirm on the penalties of perjury that the testimony you'll give in these proceedings will be to hold yourself, you God.
Yes.
Since you were in court in front of me when I sentenced you on March 4 of 25, have you been arrested?
No.
Any new charges?
No.
Prosecutor says if defendant in full compliance, no objection, defer to the court's discretion. I'm going to go ahead and dismiss your case. I sincerely wish you well. I hope you remember this. Don't no more of this nonsense, okay?
Thank you.
You with me? How old are you? Pardon?
25.
You working?
Yes.
Where at?
I was at the restaurant Trent Ruligan Schoolhouse, and I'm a mother also.
Well, congratulations. Show that child an example, boy or girl.
I have 3, 2 boys and a girl.
3 kids. Whoa. Good luck to you. Dismissed. Good luck, ma'am. Thank you very much.
Thank
I
you.
wish you luck.
Right.
Bridgewood versus Stephanie Murphy,
Right to the podium.
2503298 LT.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
All right, Ms. Murphy, good morning. Your name? Ms. Murphy, come on up here and tell me your name, please.
Well, my name is Beth Murphy. I'm a daughter.
Your name?
Stephanie Murphy.
I know, I remember. I got it. You can't.
Over here. I apologize. We were here last week.
I know. I just can't let you represent us. Ms. Murphy, tell me your name, please.
Stephanie Ann Murphy.
All right, what do you think is owed on this one? State your appearance, Mr. Burns.
Yes, good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff. We're showing rent to retain of $2,593, costs in the total of $191.11 for a total due and owing of $2,784.11.
Do you agree that you owe that amount, Ms. Murphy? I can't let you
I know,
represent
but she
her.
has Alzheimer's.
I-
Should have told you that
Then
last
you
week.
gotta get a lawyer. You gotta get a lawyer. I just can't, I cannot let you do that.
All right.
Was another payment made that makes this less than $27.84? No? I'm asking you.
Me?
Yeah.
No.
Okay, so she agrees that she owes that amount, right?
Well, we haven't been living there. She hasn't been living there since like late May, early June because of bed bugs. We were forced out. She was forced out of there because of bed bugs. Can't stay there. I handle her bank account.
Did you turn over the key?
Yeah. I spent the entire summer cleaning out that place, throwing everything out for her.
All right, let's slow down. Let's slow down. All right. Department manager, your name.
Ginger Pelk.
Did they move out?
I have not received any keys from them.
They're on the counter.
Well,
Wait a minute. Did you guys have a complaint of bed bugs?
Yes.
Ma'am,
Sorry.
I'm
I'll let her and Tim Murphy talk.
Did you have a complaint of bed bugs?
Yes.
Who said yes? I'm asking you guys. Come on, just
Your
tell me.
Honor, I have no knowledge of it. and My
I'm
client
talking
does
to
not.
Bridgewood's manager here. I'm asking
I
her.
thought you were talking to them.
No, I'm
Yes.
talking.
They did have bed bugs. I found out because they told the neighbor, had it treated. And she said, well, I haven't been living there fully because of the bed bugs, but we've not received any keys. We've treated the apartment. There is a co-signer also on the account, and I tried calling him too, and no response from him.
Who's him?
I'm sorry.
Who's the co-owner? I mean, the co-lessee.
It is the father. So it would be Stephanie's, I believe, ex-husband.
Tim Murphy, come on here. Jeez. Tim Murphy, you got to come up here.
He's on Zoom.
I'm on.
You got to start your video.
Okay, I'm on.
All right, I'm going to ask you to take your head off and tell me your name.
Timothy Murphy.
When did you leave there?
I never lived there. I was co-signed it because Stephanie's income from Social Security wasn't enough to cover, so I added my name to the co-signing it so they could afford the apartment.
You didn't add him as a party, Mr.
Excuse
Brown.
me?
Your Honor, if I may speak to that, I'm looking at the lease right now. I'm not seeing Tim Murphy as a co-signee. I'm seeing, at least on the lease that is dated beginning October 14th, 2024 to October 31st, 2025. The only signatory on the lease is a Ms. Stephanie Murphy.
All right. Okay.
Well, I did sign it though.
Slow down. You did or didn't?
I did. Ginger knows that.
There is a separate form that our guarantors signed, but not on the original lease. They signed an addendum to the lease that they are co-signing.
All right. So we have a problem here. Doesn't look like you have all your parties in the case. And
Your Honor, I think we can resolve this. If they're indicating that they haven't lived there and the keys are on the counter and they don't intend to retake possession of the premises, then this case can be resolved by my client simply receiving the keys from the defendants. It sounds like they don't intend on living there in the future. And rather than going too far into the weeds with this, if my client can just receive possession of the premises back, I think we can have this case resolved.
Stephanie, you need to listen to me. Okay? They are offering you, and if you don't understand something I'm telling you, I want you to put your hand up and I'll start over. Fair? They are offering to enter into a consent order of dismissal where there will be no judgment entered, and you can turn over the keys by, let's say, tomorrow at 4:30. And if you do, that the case will remain dismissed. Is that agreeable with you?
Yes.
So counsel, will you prepare a consent order of dismissal, no judgment, and say the case is dismissed with prejudice? However, defendant shall turn over the key to the property and vacate no later than September 3 at 4 o'clock.
Your Honor, I have no, I'm sorry.
You will.
I'll wait for the court to be done. I apologize, Your Honor.
That's all right. I'm used to being interrupted. Case will remain dismissed with prejudice so long as defendant turns over the keys. Is that fair, Mr. Burns?
Your Honor, I have no problem with those terms, but I can't dismiss it with prejudice, but I'd be willing to do everything else. I have no problem
You're
doing
not going to turn around and sue him for rent, right?
I can't speak to that, Your Honor. I mean, it's
Well, I thought you just said you were going to dismiss it if they turn the keys over. If not, we're going to have the battle now.
And Your Honor, I understand that. My
You understand
client, I
what
don't
I'm
want
saying?
to.
Because I don't know that they owe you anything if the bed bugs were that bad and they haven't been in there.
But my
So why
client's
don't you pull a
contention,
breakout room and talk to the apartment manager? Because it's not fair to them to have them turn the key over and then have you start a lawsuit against them.
Your Honor, I don't
You
want to
can think
foreclose
I'm
my.
wrong, it's okay, but I'm not gonna do that otherwise. It's not fair to them.
Let me ask my client this. Ginger, would you be willing to dismiss the case with prejudice?
And an indication that no money judge will be pursued for past due rent, period.
Yeah, but I can't make that decision, but I'm going to tell you my corporate office will go after them for rent. The bed bugs were not caused by us.
Oh, then that's fine. We'll just adjourn it a week. You're gonna have to get a lawyer, Stephanie. If you're gonna fight this on a bed bug issue, you're gonna have to get a lawyer. Your daughter cannot represent you.
Okay.
That's what I'll do. I'll adjourn it 1 week and we'll set it for trial. Everybody has to come in. I mean, it makes sense. Did you not ever tell the manager you were leaving?
Me?
No, I'm talking to the party here. Did you ever tell the manager that you were leaving, that there were bed bugs on the property?
Yeah, they,
Hang on, ma'am. Talk to me. I don't want to be interrupted over here. Did you ever tell the manager, either in writing or in a phone call?
Emanation.
Why am I getting interrupted here? I'm not in the mood to
I
get
muted him,
interrupted.
Judge.
What's that?
I muted him. He's just talking.
Thank you. I want to know if you ever told the manager or wrote the manager and said, we got bed bugs, we're moving out.
Yes, they were aware of it.
You told them, answer my question. Did you? You got to step back, young lady. I cannot let you do this. Stephanie, stay right here. Just talk to me. I don't bite. I just want to know if you told the manager that you were leaving and that there was a bed bug issue.
They knew about the bed.
I didn't ask you
They're
that.
right next door to us. And I had told them and showed. them.
Told, who's them?
The next door neighbors, the people who rent them.
I'm
Our
sorry?
neighbors, our next door neighbors.
You told your next door neighbors?
Well, yeah,
Did you tell the manager?
she is the manager.
Do you live next door to her?
I do not. I found out they had bed bugs because they told their neighbor that they weren't staying in the apartment because they had bed bugs. That is how I found out.
How did you find that out?
Oh, I would have to go back through the emails. I was not under.
How did you find that out?
Hold on. I'd have to go back through my.
Take your time. What day, Stephanie, did you move out of there? Do you know?
It was, probably 2 weeks ago.
2 weeks ago?
No,
Ma'am, sit in the back now. Next move you say, I'm sending you out of the courtroom. Sit in the back.
she's my daughter and she lives with me.
I know, but I can't allow her to represent you.
can I say something, Judge?
No, you can't. You're not even a party either. Stephanie, I want you to look at me. If you're feeling pressured, tell me, Judge, I'm feeling pressured, and I'll let you go hire a lawyer and come back next week. Okay? Do you remember when you told, so you're saying you stayed in there until mid-August?
Yes.
When did you have it treated for bed bugs? No, I'm asking you, the manager again. I did not catch your name, so I've got to ask you again. What is your name?
My name?
No, the manager. Are you
I'm
listening?
sorry, I'm looking at her account. My name is Ginger.
Ginger what? Pelk?
Yes,
PELC?
correct.
Ah. When did you have the bugs treated, and when were you notified by the neighbors or Ms. Murphy or anybody else on the planet that they'd vacated the property?
Yeah, I was trying to pull up the emails, her account. I can tell you they were charged for the bed bugs on July 1st. I charged them for the treatment
Why'd they get charged?
because they have the bed bugs. Nobody else had the bed bugs.
Okay.
Our normal extermination does not cover bed bugs.
Okay, July 1 is when that happened, right?
Yeah, that's when they got charged. They paid July's rent too.
So all we're talking about here is half of August rent or all of August rent, right?
They
Yes, Your Honor.
yes.
Well, man, when were the bed bugs treated?
I'm trying to pull up that right now. Bear with me. I'm sorry.
You lived there after the bed bugs were treated, Stephanie? Stephanie, look at me.
Oh,
Did you treat the bed, did you remain in the property after the bed bugs were treated?
yes.
For how long?
Maybe a couple of weeks. It was not very long.
So I pulled up the addendum to the bed bugs. So they were charged July 1st for the bed bugs, but because they left their cats in there while they were not living there, and they didn't get the clothes properly prepped, we did not end up treating till July 29th because they moved out and left 2 cats in there.
Wait a second. You just got done telling me that they left 2 weeks ago. When do you think they left?
They weren't staying there because of the bed bugs, but there was still clothes in the bedroom, mattresses, couch, kitchen table, and 2 cats. I know the cats they had to remove for us to treat on July 29th. But I have not heard from them.
All right,
They
Stephanie.
told me they were not
I would
staying there
like to come
because
up
of
here and I'm gonna ask, Mrs. Murphy, what's your name again? Beth what?
Murphy?
Come on up here. Now, I'm gonna tell you, I'm gonna ask you questions or two because I'm gonna let you be kind of a witness here. But if you answer out loud without me directing you again or without me addressing you again, I'm sending you out to the hallway. Do we understand one another?
Yes.
All right. Now you can tell me when, were you living with your mother
Yes.
until she moved out?
Well, we both moved out.
I understand. Okay. When was that?
Late May, early June.
Hang on. You're saying you left late May, early June.
Well, you guys not living there.
She's saying, Stephanie told me 2 weeks ago, which would make it around August the 17th or 18th. They say you had cats in there after they knew of the bedbug problem in July. Is that true or false?
Cats, yes.
Well, the cats were still there, right?
Cats were still there.
Well, then you didn't move out. You never turned your keys over. You still were occupying the property. I'm just amazed that you guys didn't communicate with the manager. I think a lot of this could have been avoided. You don't just tell your neighbors, I'm moving out, I got bed bugs. And leave cats there and then come back and I'm not keeping you up, am I?
Sir.
Sir, I'm not keeping you up, am I?
No.
Okay. I don't want to keep you up. Okay, all right. Mr. Burns, can you not just go in a room and talk to this Stephanie Murphy with her daughter there and see if you can't resolve this?
I'm willing to do that, Your Honor. I do have one other matter I'm trying to wrap up in a different court. So if the court puts us in a breakout room, I'm willing to address these things. I just want to let you
Put
know.
you guys in a breakout room with Mr. Burns. Stephanie really has to do the talking. It looks like You gotta handle this better. You can't just walk out of there, leave cats in there. You still occupy the property.
Right.
You didn't turn the keys over. Was this still during the lease period, Ms. Pelk?
Yes, they're still in a current lease until the end of October.
Did you guys stop and think about that before you started leaving? You're gonna get stuck paying this rent again. You can't just move out. I'm just telling you. Where do you live now, Ms. Murphy? Stephanie, where do you live?
I'm still there. No.
I get Alzheimer's. I understand Alzheimer's. I cannot let you represent her. Ms. Murphy, talk to me. You just explained to me that you left 2 weeks ago, right?
No, yes, no. I did not leave 2 weeks ago. I left recently.
What's recent?
Yeah.
Okay, so you've been in there the whole time.
Yeah.
I'm going to let you guys go talk to Mr. Burns. He has another courtroom to go to. My court officer's going to take you to a computer and you can Zoom with Mr. Burns. He'll explain it to you and we'll go from there, okay? Jaleel Harris, Jaleel Armani to Sean Harris, 25M 577-119A and B. Your name? You didn't show up last time.
I had an incident in Ohio. I was beat and I had to go to the hospital. So
You got a fight?
no, I got all set up. So yeah, they had my phone and I forgot the date. And I had to work.
All right. Today is a state docket day. We are going to send you to the prosecutor. Would you like a lawyer?
I don't got a lawyer. So
No, do you want one? I'll give you one if you want one.
sure.
Give him a lawyer. So that one needs to go down, that one to the lawyer. We'll go from there. Mr. Williams, what are you here on, sir?
Your Honor, I've got several cases. These are probable cause conferences.
Okay. Mr. Shumke,
Here's Williams.
oh, you're the prosecutor.
Snyder is ready also, if that's in there.
Patrick Fallahy, Patrick Darren Fallahy, 25W7199969. Okay, Mr. Williams, your name?
Rodney Williams, on behalf of the defendant, 47888.
Your name, sir?
Patrick Darren Fallahy.
All right, so we're going to go with the exam next week.
Judge, the victim's on Zoom also.
Where's the victim? Who is the victim?
You put my note on the register too.
What's that?
They sent this.
Here?
Yeah, if you look at my note, you'll see. I don't know if Mohammed saw it or not.
Can I have the defendant call me as well afterwards?
Yeah, but now I'm getting handed paperwork. I need Mr. Muhammad and I need the victim to show up and state the name. Victim, you need to sign in.
This case belongs to the domestic prosecutor.
Okay? We need the domestic prosecutor, whoever that is. Victim, you need to sign in. It says victim Fallahy. I need you to start your video.
Oh, I have the video, but
What's your name?
Nicole Beach.
Okay. Let me check a couple things, counsel. I don't even see. Okay, you've got the bond conditions in the lien, right, Lisa?
I can check, Judge.
I've got them right here. I'm gonna reiterate them. Can you give me a bond sheet? Stay right where you are, Ms. Beach, please.
Okay.
The prosecutor's out of Zoom.
Oh, there you are. How you doing, Ms. Louie?
Hi, how's it going?
Good, you?
I'm good.
Yeah, you had a good honeymoon and all that? You're all...
Thank you.
State your name, please.
Noor Alawi on behalf of the people.
All right, I need a bond sheet and there was something that was emailed to us about a bond violation. So let's start with that. But first of all, I'm going to go ahead. I'll note that Judge Burton he must have been sitting as the magistrate that day, or the visiting judge that day, I should say. Ordered no contact, no assaultive, abusive, required to obtain a tether. I need to check one thing, counsel, real quick. So no contact. Who's Ashley Olette, Ms. Beach?
She's my friend who was with me that night and was also assaulted or almost assaulted.
All right. Jeez. Cool. Nicole Beach or Ashley Olette, no contact with them at all. No contact with prosecution witnesses. You're not to possess firearms. That was not ordered. If you have firearms, you have to bring them over to the Woodhaven.
I have no firearms.
No firearms, no dangerous weapons. You have a tether?
I do, sir.
All right, let me just see something here. Who lives at 23020 Fairway Drive, number 204, Ms. Alawi?
I believe that is the
It's me.
complaint witness here. I'm just going to double check.
Mr. Williams, I need you back in here. I don't know what happened. I just see a picture of you.
All right.
That's okay.
Sorry about that. I just don't want to be wrong here. I have
That was the location of the
that
found.
location is complainant Miss Beach's home.
Okay. So you're not to enter the property address or go near 23020 Fairway Drive,
Yes, sir.
Unit 204 in Woodhaven. Lisa, we're going to have to communicate. I have no idea what the terms of this tether are, but you're not to be within 2 miles of the victim,
Yes, sir.
her residence, or place of employment.
Yes, sir.
You have to get that straightened out, Mr. Williams, with the tether unit at the sheriff's department.
I go there.
Hang on. I don't know what the judge ordered. I can't tell. He didn't fill out a bond sheet, I don't see. But those are the conditions. You're not to be within 2 miles of the victim or residence or place of employment. You're not to leave the state. You're not to violate a law. You must appear in court as directed. Again, no contact with Nicole Beach or Ashley Olette. You cannot write, phone, see, text, email, or communicate with them or have anybody else do any of those things for you or on your behalf. You also have to show up in court. Are we doing September 9th on this, Mr. Williams?
The 16th, Your Honor.
The 16th. Okay, so you have the right to a preliminary examination within 7 days of the date of the probable cause conference. Today is the probable cause conference. Are you not available next Tuesday, counsel?
I am not, Your Honor.
Your lawyer has a conflict, so he's asking me to adjourn it for 2 weeks. Do you waive your right to have the exam within 1 week of the date of the probable cause conference?
Yeah.
Anybody force you to do that?
No.
Preliminary exam will be September 16th, Lisa, at
10:45.
at 10:45. I want to be clear. So, Mr. Williams, you're going to have to deal with the tether unit Make sure they understand that tethers to prohibit him from going within 2 miles of the victim, her residence or place of employment, and that goes for both victims, Ashley Olette or Nicole Beach. So he's going to have to get that straightened out. I don't quite understand what Judge Burton ordered totally. So that's the best I can do. Do you have any questions, sir? Now, there was an issue here about bond, and we got an email. I'm just looking at it. It says Patrick Valley was arraigned out county over the past weekend, instructed in his release order not to have any contact or direct or indirect contact with Nicole Beach. 2 separate reports have been made by Nicole where she stated he's texting her and calling her, requesting a hearing to violate his release order and have his personal bond revoked. Apparently, your client doesn't listen very well. Do you want to confer with him as to whether or not he wants to plead guilty or wishes to have a hearing?
Yes, I would, Your Honor.
We're going to put you in a breakout room to speak with your lawyer. When a judge tells you no contact, I want you to understand that's what they mean. Do you understand me? That means you cannot write, phone, see, text, go anywhere near them, have anybody in the country or the world contact them for you on your behalf, whether by text, phone, letters, in person, email, otherwise. Do we understand one another?
Yes.
Go talk to your lawyer. I'm dead serious about what I'm saying.
Yes, sir.
Your Honor, if I may be put into a breakout room with the victim here.
Yeah, we'll put you in a room with Ms. Beach, and you're going to be in a room with your lawyer, and then you're coming back, and we're figuring out how we're going to proceed here. Do we understand that? Cody Snyder.
And if it's easier,
Cody,
I'm sorry.
is Mr. Carmen Cody Snyder's lawyer?
Coming in right now.
People against Cody Clayton Heath Snyder, 250-706-513. Mr. Carmen, your name?
Good afternoon, Your Honor. Michael A. Carmen, P73824MF.
Mr. Snyder, your name? Start your video, sir. Your name?
Can you hear me?
Yeah, your name?
Cody Snyder.
We're setting this for September 16th. You need instead of the 9th, right?
Yes, Your Honor, please.
Sir, you have the right to a preliminary exam within 7 days of the date of the probable cause conference. Today is the preliminary exam. If I adjourn this per your lawyer's request, that means the probable cause conference, the exam will not take place within 7 days of the date of the probable cause conference. Do you understand that?
Yes, sir.
Do you wish to give up that right? Or do you want to force him to come when he's not available? It's up to you. Whatever you want. I'd just as soon get it out of here next week.
What do you think?
Cody, I'm not available the 9th. Can we do it?
Okay. Okay, I understand.
Do you wish to waive that right?
Yes, sir.
Anybody force you to do that?
No, sir.
I'll accept the waiver. We'll set this for September 16th. Let's go 10:45 on this one too, Lisa, okay? 10. Did you tell me 10:15 or 10:45 on the last one?
10:45.
All right, we'll do this one at 10:45. Thank you both. Have a good day. Anything else, Mr. Carmen?
No, sir. Thank you so much, Your Honor.
Have a good day. Thank you.
You too. Thanks.
Thank you.
Good luck. What all you people have there?
Mr. Williams. I'm still waiting for Sean to get out here.
Oh,
Yeah.
this is another one.
People against Doolin. Deshaun Lamar Doolin. 25B716761FY. Doolin. Mr. Williams, your appearance?
Thank you. I'm here, Police Corps Rodney Williams on behalf of the defendant.
Mr. Doolin, your name? You have to start your video, sir.
Deshaun Doolin. I'm sorry, I'm trying to figure out how to do it now.
Bottom left-hand corner of your screen.
Okay. Can you see me now, sir?
No, now I can. Yes, I can. Your name?
Deshaun Doolin.
All right, so your lawyer wants me to set this for a preliminary examination on September 16th. He's not available on the 9th. You have the right by law to have your preliminary exam within 7 days of the date of the probable cause conference. If I grant his request to adjourn, that means that the preliminary exam will not take place within 14 days of the date of the arraignment. Do you understand that? I'm sorry, will not take
yes,
place
but no.
within, let me rephrase that. If I adjourn it for 7 more days to the 16th, that means the preliminary exam will not take place within 7 days of the date of the probable cause conference. Do you understand that?
Yes, but no, because I'm not really sure what that means exactly. I understand you're saying it's going to be rescheduled, but I'm not understanding what that I'm missing, I guess.
Okay, he wants me to set it in 2 weeks.
Right.
He's not available next week.
Correct. Okay.
I have to tell you, you have the right to that preliminary exam within 7 days.
Yeah, that's what I'm asking.
Today.
What is the preliminary exam?
That's where they have to show that the crimes were committed, any felony crimes, and that you were the one who probably committed those.
I would like that then.
I understand, but I want to make sure, do you waive your right to have the preliminary examination next week? In other words, can I set it for September 16th?
Okay, so it's still going to happen. It's just going to happen a week after what you're saying. Correct. Okay.
You
Yes, sir,
waive
then.
that right?
Yes, sir.
Anybody force you to do that?
No, sir.
September 16th at 10:45. I'll see everybody here then. Anything else, Mr. Williams?
You can put him in a breakout room with me right quick. It'll take 2 minutes.
Sure. We'll do that. Thank you.
Thank you, Your Honor.
Susan O'Hara. Susan Marie O'Hara, 25M097301. Good morning.
afternoon, Your Honor. Mr. Schenker here again. My client approaches to be staying.
I guess it is afternoon. Your name?
Susan O'Hara.
All right, what do we have here? What are we doing on this?
Your Honor, I believe that the AG, Mr. Gunderson, should be on. He and I have had dialogue. We're still in the process of getting discovery. There's a lot of it on this case, so we're going to be asking for an adjournment of the PC.
Where's the prosecutor? Yeah, Mr. Gunderson, good morning.
Good morning, Your Honor.
Your appearance?
Dan Gunderson, Assistant Attorney General for the People, P number 74490. I'm also joined by an Assistant Attorney General from the Revenue and Collections Division.
Oh, we got all the big shots here from the state, huh? All right, go ahead. I'm sorry. Your name, Ms. Johnson?
Denise Johnson, Assistant Attorney General, and I am representing the Department of Treasury, P62840.
What's this case about, counsel? Can you tell me, Mr. Gunderson?
Yes, I can, Your Honor. This case is about an alleged embezzlement from an employer by the defendant, as well as cashing checks in the name of a client, and that describes the ID theft charge as well as the forgery charge.
What do you guys want me to do? I didn't even get it. I just came back from vacation. I got in and saw this motion sitting on my bench or on my desk, and I didn't get a chance to read it. I was off on vacation this morning.
Yes, Your Honor. We have two disclosure motions. I believe one has already been signed by the court, and that was for general discovery, a protective order. However, Ms. Johnson represents the Department of Treasury, which requires its own separate protective order for tax information. All the discovery except the tax information has been provided to defense counsel.
So, Ms. Johnson, you just want me to sign the order permitting disclosure of taxpayer information pursuant to 205-281F, correct?
That's correct. And
any objection?
No, Your Honor.
I'm going to go ahead and sign that orders. So you stipulate to this, correct, counsel?
So stipulated. I've been in contact with brother and sister counsel. They've sent that documentation. I've read it, reviewed it.
I will go ahead and sign that as is. And then let's talk about dates. When do you want?
Judge,
you're not going to tell me too long.
No, Judge, I'm very familiar with this court's policies. I'd ask for adjournment for 2 weeks of the PCC. I'd ask for the September 18th.
We don't.
16th, I'm sorry.
I'll do it if we're going to exam on. Can we set the exam within a week thereafter?
I have no objection.
I don't have to do this on a Tuesday, Mr. Gunderson and Ms. Johnson. So I'll be glad to adjourn the PCC to the 16th. Can we do it on either the 18th. Lisa, I want to make sure that I'm good on either the 18th or the 22nd.
You can't do the 18th. You have that sobriety court class,
Oh, yeah. What time's that end?
12 to 1:30.
How about the 17th?
Is that for the
Exam.
17th is good, but it is a Wednesday.
Are you guys good on Wednesday afternoon, Ms. Johnson and Mr. Gunderson?
I'm sorry, Your Honor, I have.
That's okay. Let's go to the following week. How about the 22nd?
22nd is good for the people, Your Honor.
Ms. Johnson, is that good for you?
My purpose is getting the tax motion signed, so I am.
So you don't need to be here for the exam?
I don't.
All right. Is that good with you, Mr. Shemke?
You're sending the exam, so you want to have the exam on,
PCC will be the 16th. And the preliminary exam will be the 22nd. At what time, Lisa, are we going to do these?
11 o'clock.
Yes, as far into the morning or the early afternoon as possible, because I just have a preliminary matter wind down.
Can we do 1 p.m. on the 22nd, Lisa?
Yes.
Okay. And what time do you want me to set the PCC for?
8:30.
That's fine, Judge Henry.
All right, ma'am, I want to make sure you understand everything. You have the right to a probable cause conference within 14 days of the date of the arraignment. Your lawyer needs some more time to prepare. He's asking me to set this for the 16th. Today is actually the probable cause conference. You also have the right to a preliminary exam within 7 days of the date of the probable cause conference. If I adjourn those 2 dates, that means you are waiving those rights. Do you understand that?
I do.
Do you wish to waive those rights?
Yes.
Anybody force you to do that?
No.
September 16th at 8:30 PCC. Preliminary exam, September 22 at 1 o'clock. Anything else, Mr. Shemke?
No, Your Honor.
Mr. Gunderson?
No, thank you, Your Honor.
Obviously, the exam will be in person. Ms. Johnson, anything else?
Not for me, thank you.
Any questions, ma'am?
No.
Thank you very much. Have a good day. Thanks.
Thanks,
People against Cummings, Crystal Lee Cummings. This is 23F7209. 611. How you doing, Ms. Cummings?
Better days, Judge.
Good. Your name?
Crystal Cummings.
Mr. Williams?
Thank you. I'm pleased to call Rodney Williams on behalf of Ms. Cummings.
This will be a waiver of the preliminary exam, true?
That is correct, Your Honor.
Is that what you want to do, ma'am?
Yes, Your Honor.
You have the right to a preliminary examination on these charges. If that preliminary exam, the people would have to show that the crimes were committed and that you were the one who probably committed the crimes. In this case, you have, let's see, give me 1 second, please. You have 1 count of flee and elude 4th degree. You have a super drunk. You have a drywall suspend 2nd. So the only case that you have the right to an exam on is flee and elude 4th, which is a 2-year. Do you understand that?
Yes, sir.
If you waive that right, that means you'll automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, Your Honor.
Anybody force you to give up your right to a preliminary exam?
No, Your Honor.
And you still wish to do that?
Yes, sir.
I'll accept the waiver. I'm binding you over to the Wayne County Circuit Court.
Judge,
Yeah.
we got a call from the Wayne County Sheriff's Office. They want her placed in custody. They're on their way to get her.
They're in court now.
Oh, okay. I didn't see them. There's a bond issue, apparently.
Uh-oh. Uh-oh. Uh-oh.
Hold on, ma'am. Let's go to the judge.
Sorry. I bonded out and we were supposed to go down there and I was just waiting to go down there to, because you have to go after you get bonded out.
Go after. I don't know what you're
I
talking.
have to go down to the.
To get a GPS setter, was it?
Yeah.
Did anybody order a GPS?
No.
Hang on, slow down. Just slow. Well, I'm going to sort through it. Just relax.
Judge, I believe the wrong amount was posted. That's
How
the
much
issue.
did you post? Did you post 1,500?
They was 300.
How'd you only post 300?
I already had the bond, I already did my other court case.
Is anybody here from Lieutenant? Your name?
Good afternoon, Your Honor. Detective Lieutenant Chris Remba, City of Flat Rock Police Department.
Has she been Has she been fingerprinted and photographed?
I do not believe so, Your Honor. Not on this case. I'm double checking now, Your Honor.
Were you printed on this case?
Yes.
When?
Flat run, I think it was August 21st, 22nd. When I got arrested.
Yes, she was, Your Honor, a week or two ago.
All right, so she didn't post enough? Is that what happened?
I'm guessing. Yeah.
What's that?
I got money to post.
She posted 300? Is that right, Lisa?
Told that the jail took $150 instead of $1,500.
So it should have been 1,500. Do you have the other 1,350?
I can get it. I don't have it on me, sir. I have, 440 for $500.
And she's posted 150. You're sure of that, right, Lisa? Just slow down. How much did you post?
300.
Come on up here, Mr. Mohammed.
I have the paperwork.
Okay, go get the paperwork. I'm letting her go there. So. I'm going to try to save you a little trouble. So, Mr. Mohammed, I ordered 15,000, 10%. That was at an arraignment. Excuse me. August 22nd. And I'm told she didn't post the right amount.
Show the process.
Hang on a second, Mr. Williams.
Yeah, this is 150.
So she only posted 150, and he has 500.
And it was 15,000?
10%. I'll tell you what I'm gonna do. Do you have any objection, Mr. Mohammed? This is flee and elude fourth to a 6,500, 10% bond. I'll take it off your hands. I'm gonna lower it to 6,500, 10%. The defendant still showed up here. 6,500, 10%. So post the other 500, that'll be 650. And then you're all set. You can walk out of here and the deputy sheriff doesn't have to take you back down and then.
Thank you, sir.
So that's what I'm gonna do, Mr. Williams, 6,500, 10%. I'm accepting the waiver. You wish to give up your right to an exam, correct?
Yes, sir.
Nobody's forced you to do that?
No.
All right, so I'll accept the waiver. But 6,500 is 10%. You have exactly at least 500 on you, true, sir? Don't tell me it's less.
Yes, sir. No, I have exactly 500.
Good. Go down the hall, post the other 500. And, ma'am, I'm going to ask you to just stay in the courtroom until then, okay? And that means since you're posting today, we're going to set this out for 2 weeks until the 16th of September at 9 a.m., okay?
So that was a waiver of the preliminary examination, Your Honor. Hers.
No, I know. I'm taking the waiver. I'm setting her arraignment on the information in circuit court on the 16th at 9.
Thank you, Your Honor. Thank you, Your Honor.
If I misspoke, tell me. I might have. I'm still on vacation, Mr. Williams.
No, I'm fine, Your Honor.
Beautiful up there. I was slashing the golf ball all over the place though. Right, left, long, short, in the trees, in the ponds. Crazy. All right, so that's it. That's what we're doing. As soon as he posts, you go down and get your notices. Thank you both very much. Have a good day. All right, now, I need, wait 1 second. What did they do? Bridgewood versus Stephanie Murphy, 2503298.
Good afternoon, Your Honor. Again, Michael Burns, P 87855 on behalf of plaintiff.
Where's Stephanie Murphy at?
They are in the hallway, Your Honor. They should be on the way in soon, if not in the courtroom already.
Is this resolved?
Yes, Your Honor. We're doing a conditional dismissal.
Okay. All right, just wait till they come in. And we'll get rid of that one.
Just go back to the podium.
Just her?
Yep.
Come on up here, ma'am. Ms. Murphy, come on up. Bridgewood versus Stephanie
Right
Murphy,
to the podium here.
2503298.
Go this way, come on.
All right. Your name?
Stephanie Murphy?
Right there, right there.
Stay at that podium there if you would, okay?
Right over here.
Speak into that microphone. See that microphone? I need you to speak into that, okay? Tell me your name.
Stephanie Murphy.
All right. I need your name again, Mr. Burns, and then Ms. Belk's appearance again, and we'll go from there.
Thank you, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Help Bridgewood manager.
All right. Just if I call on you again, you have to speak more directly into the microphone, Ms. Pelk. We're kind of getting some of your words, not others. What are the terms of this conditional dismissal, counsel?
Your Honor, the terms of the conditional dismissal are that the case will be dismissed pending the defendant turning in keys to the unit by tomorrow at 4:30 p.m. My client would be dismissing this case without prejudice. I've informed Ms. Murphy that my client does wish to recover the past due amount because the tenancy had continued. So we would be dismissing the case without prejudice as long as the keys are turned in by 4:30 tomorrow. I would just ask that the court confirm with Ms. Murphy.
Ms. Murphy, I want you to listen.
I am listening.
Okay. They're going to dismiss this case without prejudice, meaning they can bring the case again as long as you turn in the keys by 4 p.m. tomorrow. Do you understand that?
Yes, I do.
Do you agree to that?
Yes, I do.
Do you understand they're going to turn around and sue you for non-payment of rent, though? They're going to turn around and sue you for non-payment of rent for, I heard that you paid July, so at least for August and probably September. Do you understand that?
Yes.
Do you still wish to settle under those terms and conditions?
Yes.
And Ms. Murphy in the back, I just want to make sure, I want to extend this courtesy. Does your mother understand everything I just said with her? You would have talked to her on Zoom with Mr. Burns.
She understands, but she won't remember it tomorrow
Okay,
or next week.
okay. I wish I could have yeah, I get it. I get it. I'm sorry, ma'am. Do you understand though?
Yes, I do.
All right. September 3rd, turn that over by 4 p.m. They're going to turn around and sue you. You understand that, right?
Yes.
Do you have any questions for me?
No.
I sincerely wish you well, Miss Murphy. Ma'am, these are not my rules in the back. I have to comply with them though, okay? Good luck to you. Good luck to you both. And good luck to you, Ms. Pelk and Mr. Burns. Is that it for you, Mr. Burns?
Yes, Your Honor, it is, and I appreciate the court's patience and Ms. Murphy's patience, so thank you all.
No problem. Thank you very much. Mr. Cooper, you have a case out there, huh?
I do, Judge, a PCC. I need
Okay.
to speak with Mr. Earl Smith. I didn't have any idea he would be in jail.
I don't know if he is or not.
I put you in a breakout room. Did you speak with him?
No, I was in the breakout room all alone for quite a while.
Yeah, he was in there. Okay, I'll move you guys again.
Jalil, Amarni, Deshaun, Harris, 255771119 A and B. Good morning,
Good
Council.
afternoon.
Geez, I keep
Judge,
saying more.
staff, John Rossani, P number 43387.
You're,
Discuss this matter with the prosecutor, and please introduce yourself, Mr. Harris.
My name is Jalil Harris.
does he stand mute? Wait for him to read it.
Yes, sir.
And that's on the suspend, and now the prosecutor is going to dismiss the suspend if he pleads to 85 and a 70, true?
That is correct.
If you do that, sir, that's 2 points on your traffic record. Do you understand that? But then I'll dismiss the suspend, that's a misdemeanor, do you understand that?
Yes.
Is that what you want to do? To the charge of 85 and a 70, responsible or not responsible? Plea is accepted to 85 and a 70. I'm going to go ahead and dismiss pursuant to stipulation the driving on a suspended 185 You can go right down the hall and take care of that, and you're all set. You can pay that now, right, sir?
No, he's not in a position.
How much does he have today?
He has nothing. What's happened is he lost his
When can
job.
he, just tell me when he can pay it.
He can probably pay in a month, am I correct?
Where were you working? Why'd you lose your job?
I was really beat up and my job didn't accept that.
October 2nd pay by. Now listen to me. Sometimes things happen in life, right? Air conditioning goes out, the engine goes out. I don't know. You need new tires. I don't care what it is. If you don't have the money, you don't have to worry. Just call the court. We'll go on Zoom on or before that due date, or walk in here on or before that due date. I'll be happy to give you an extension, okay? Just don't ignore me. All right, you understand? All right, good.
Judge,
Good
Smith,
luck.
thank you.
Have a good one, Mr. Graziani. Good to have you here, by the way.
What's that, Judge?
Good to have you here.
Well, pleasure always.
Thanks.
Always a pleasure.
All right, Mr. Williams. Oh, no. I'm sorry, you're still in the breakout room. My apologies. I just wanted to make sure I wasn't keeping you. Go ahead, I'm sorry. Take your time.
No, we're ready, Your Honor.
What case are you ready on?
On Deshaun, no, strike that, Patrick. Haley.
Oh, yeah, where's that one at? I need that file again. Unless Ms. Aloui has it, the domestic prosecutor.
I don't know.
I'm gonna need her in here too.
It's
Mr.
down
Chair-
here.
It's down there?
Yeah, it was in your stack of done files.
Okay. We'll be back with you in a second. Mr. Shemke, do you have another case?
Yes, I do, Mr. Abraham.
Do you have that one down there?
What is it? Abraham Thomas.
Thomas Abraham?
Yeah. He's up for a show cause. I already spoke with Ms. Cooper. I've seen the violations. We're not going to have a hearing.
Okay, do you have the file?
I do not. Probation violation?
Yes.
Probably.
Well, you're stuck with me for 4 months. Mr.
Oh,
Fun? You call this fun, huh? Abraham, Thomas Patrick Abraham, 24W8330005B. All right, I'm gonna need a probation violation sheet, please. I sentenced him on, where's Mr. Shemke?
right there. You want me to stand in?
These guys are like ninjas. Go get your lawyer, will you? Why'd you run out of here? All right. I can just fill it out. All right. People against Thomas Patrick Abraham. 24W8330005B. Counsel, your appearance, and Mr. Abraham, your appearance, and Ms. O'Donnell.
Good afternoon, Your Honor. Mr. Shemke, here on behalf of my client, who approached and stands to my immediate left. You state your name for the record, please.
Ms. O'Donnell?
Just going on behalf of probation.
All right, so this case is a probation violation. This alleges that the defendant failed to refrain from consuming alcohol or drugs, testing positive for cocaine metabolite on a chemical test of July the 29th of 25. That is the charge. How is he going to proceed?
Your Honor, as to the nature of having a violation hearing, I've explained my client's rights. He's not requesting one. He'll admit to the violation and we can only ask for an opportunity to have.
If you plead guilty here, sir, you could get 5 days. This being a first technical violation. You understand that?
Yes.
Did you sign the advice of rights revocation probation and read it and understand it?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that? Can I have the screening, please, to the charge that you failed to refrain from consuming alcohol or drugs, testing positive for a cocaine metabolite on a chemical test of July 29th? How do you plead?
Guilty.
Did you test positive for cocaine on that day, for a cocaine metabolite?
Yes.
Had you consumed cocaine within the preceding 5 days?
Yes.
Anybody force you to plead guilty?
No.
Your plea is accepted. I find it to be an accurate plea. Is that what his problem is cocaine? Yeah. Cocaine and heroin. Listen, maybe you need to get in my sobriety court. Can't have you using this junk. You're gonna die. Why are you shaking your head? You don't want to get in the sobriety court?
No, I agree. I just, you know, it was in my system, and I've been tested 12 times since then.
Your Honor,
I've been
since, sober. Your Honor, since I got involved in this case, my client had a matter in Westland and Southgate. I've since taken care of the matter in Westland. We have a sentencing date next week in Southgate. I anticipate potential probationary terms. Judge, he has been testing.
What do you have on those cases?
Just drug-related case.
Both?
Yes, Judge.
What kind? Cocaine and heroin?
I believe, if memory serves me correctly, but misdemeanors, not felony charges.
Well, they just didn't charge him as felonies. So you're saying the other 12 tests have been negative?
This is correct, Your Honor. So this test that he violated on this July 29th, that was the first test. that
Tell you what I'm gonna do. We're testing him twice a week, right?
We're testing him once a week. He's been negative since the first test. Everything's been great for him. He's been enrolled in IOP now. I think, again, this was just the first put off. We had some issues, but again, he's been compliant since, Your Honor. I've had no issues with him.
I'll tell you what, I'm setting the sentencing in 3 weeks. I'll do it when you're here, Mr. Shemke.
Judge, I was.
And what do you, when are you here 3 weeks from today?
Judge, closest date I'm here would be in October 1st.
October 1st, Lisa, can we, oh no, I'm off that day, am I not, or no? What about in the morning? I could do it October 1 in the morning.
Absolutely, Judge.
October 1 at 8:30. Now listen to me very carefully. I'm not gonna send you to jail. If you come back in 3 weeks and you're positive again, you're gonna have your choice. You're either going into sobriety court or I'm sending you to jail. If you test negative all these times, I'll think I can justify this, rationalize it, and say he's on the road to recovery. But if you come back positive on any of these tests from this date until October 1, I'm telling you, you're either going into sobriety court or you're going to jail. Do we understand one another?
Yes.
How many drug convictions have you had? That's terrible. You got out of 34th, 18th, you got an armed robbery. What the heck? What are you doing? You got an armed robbery conviction?
Your Honor, I did speak. I was very curious about this as well. My client worked for Delta for 29 years. He retired in 2014. He had severe pain, and I think he got onto pain meds, and then he escalated to a different sort of.
He's on a roll here since 23. I mean, Mr. Abraham, how old are you?
61.
I mean, you're becoming a criminal. You've had 4 drug convictions and an armed robbery in the last 2 years.
It was a bad time, Your Honor.
Well, you either straighten it out or I'm gonna straighten it out. And you're not gonna like the way I'm gonna straighten it out. Do we understand one another?
We do.
I'm still not sure I don't want to go into sobriety court. I'm not making any promises. I won't come up with that, but I will be reasonable with him if he is negative. Otherwise, he's going in sobriety court or he's going to jail. Thank you. Have a good day. I need Ms. Louie in here. Recalling Patrick Fallahy. Patrick Darren Fallahy. File number 25W719969. I need Ms. Beach out here. I need the prosecutor. I need Mr. Williams. And I need Mr. Fallahy. Ms. Beach, your name.
Nicole Beach.
Mr. Williams, your name.
Thank you, Mayor. Please call Rodney Williams on behalf of the defendant.
Detective, your name.
Detective Kyle Davis, Woodhaven PD.
And counsel, your appearance.
Are you talking to me?
Yes.
Good afternoon, Nora Alawi on behalf of the people, P86528.
And your name.
Patrick Darren.
What are we doing here?
Now, we're asking for a hearing.
Okay. And what do you want me to do, Ms. Lowy?
We can schedule a hearing, just to
Well, I
clarify.
can do the hearing now. I see no reason to prolong this. I absolutely, no. It's a no contact. He's not gonna get the duck out of this. I mean, if he did nothing wrong, I'll apologize for wasting your time. But we're either gonna have a guilty plea now, or we're gonna have a hearing, and then I'm gonna make a determination. Or if the prosecutor thinks there was no contact, she can just tell me, Judge, we're satisfied, continue the bond. But I don't need to set this for a hearing. I'll give you more time to talk to him if you need it.
I'll probably need to do that then if we're gonna have it today. I'll do that.
Is Ms. Beach gonna testify that he texted her and called her?
To my knowledge, Your Honor, she will testify that she has had contact with him, or he has contacted her. Yes.
Did he text you, ma'am?
Yes.
What did he text you and when? And I'm gonna let you go in there and talk to him, Mr. Williams.
Sent them in messages, but the first few were threatening to kill my brother.
Okay. So I'm gonna wanna see those. I want you to send those texts over. Send those texts over, Lisa, at 33court@33.com or 33court.
At 33court.com.
Lisa at 33court.com. Mr. Williams can talk to his client now. And we'll go from there. We'll have a hearing.
Wondering if we can get a copy of those messages as well, so we.
Your client just said he doesn't want to go to jail today. I don't know why he'd be talking like that unless that almost sounds like a tip.
My father just passed away. I'm going through a hard time.
Excuse me. Please don't talk.
All right.
Time out on the field. 2-minute warning. Go out and talk to your lawyer further.
All right. Thank you.
And then you're coming back in here. Mr. Cooper, I'm going to try to. Yeah, I'm sorry, Miss Owens.
If I may be put in a breakout room again with the victim.
Yeah, we'll put you in a breakout again with Miss Beach.
Mr. Cooper has this case, but he also has some misdemeanors that I think Mr. Graziani is working on.
Earl Vincent Smith Jr.
Yes, sir.
25T720099. Good morning, good afternoon, Mr. Cooper. How are you? Always a pleasure.
Always a pleasure. Always, Judge. Renee Cooper on behalf of Mr. Smith.
And Mr. Smith, your name?
Earl Smith, sir.
All right, so, wait a minute, guys. Shh. So I have a felony charge here with Mr. Smith of felony firearm, possession of a firearm by a prohibited person. There's a second offense notice. So we have a 5 and 2 year felony, and we have a second offense notice, which means 1.5 times the maximum. So you could get 3 years if you're convicted on felony firearm. You could get 7.5 if you're convicted on count 1. Your lawyer tells me you wish to waive your right to a preliminary exam. If you waive your right to a preliminary exam, that means you're waiving the requirement that the people show that the crimes were committed and that you were the one who probably committed the crimes, and you'll automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, sir.
Anybody force you to give up your right to a preliminary exam?
No, sir.
Is that what you wish to do?
Yes, sir.
I'll accept the waiver. And I'm going to bind you over September 9th at 9 a.m. The Wayne County Circuit Court on the charge contained in the complaint and warrant. Bonds continue, 25,010%.
Wait, what is it? Because he's not sure what it is. It's what?
25,000, no, 50. Is it 25 or 15, John? Or,
Well, Judge, either one is, I don't know.
you don't like it?
Every jurisdiction.
I'll tell you why I did it. Just so you know. If they don't show up for a misdemeanor, what's the likelihood they're going to show up for a felony? He has 7 warrants out. That's why I did it.
I see.
So I'm not going to change my mind. I'm just not. When these guys don't think they don't have to show up and they're larger than life, that's just the price they pay.
Well, I understand that, Judge.
What are you shooting for, Mr. Smith? You think this is some kind of game where we're inviting
No.
dinner? This isn't a dinner party. You didn't show up when you were supposed to show up in courts. If you don't think a judge in the country isn't going to take that into account, I don't know what country you're talking about. It's not the United States, so I'm not going to argue with you. Your bond is continued, maybe, just maybe, but I doubt it. You'll show up in court next time. September the 9th will be the AOI date. I wish you well. Bond is continued. Thank you very much. Nice to see you, Mr. Cooper.
Good to see you. Thank you much.
Got a misdemeanor for him too, so I'm going to handle the misdemeanors. Earl Vincent Smith Jr., 20Y, 724-745. That's the other one. And then, but just so you know, Mr. Cooper, he's got Earl Vincent Smith Jr., 17F222337A. So these guys play these games with me, and then they want to shake their head and judge is a mean guy. No, judge is not a mean guy. The judge expects people to show the slightest amount of respect and show up in court. Don't raise your hand yet. I'm talking to your lawyer. All right, that's it, Mr. Cooper. Thank you. Go ahead,
For
Counsel.
the record, John Graziani, P number 43387. And hello, Mr. Cooper. Goodbye, Mr. Cooper. Mr. Vincent Smith, I'm representing you. We've received 2 offers. I should have spoken to you privately. I didn't bring my laptop, but they're minor matters. One is a DW driving while license suspended first. It would be reduced to no operator's license. Another one is driving while license suspended. Second offense would be reduced to driving while license suspended. Do you wish to avail yourself?
Well, wait a minute. The no ops has already been taken care of. He's in here for failure to pay. He was supposed to pay this back in 2017 and 19.
Judge, that was my understanding. My apologies.
That's okay. I'll take the drive while suspend first, dismiss the second. But this new case, or this 2017 case, he pled guilty as charged to driving while suspended in June of 17. June 1 to be exact, and I sentenced him when he didn't show up in September of 19, and then he hasn't paid anything. So that's for failure to pay 400. And can you tell me the total amount, Lisa? I think it was.
Bringing it up right now.
Well, let's take the plea to drive while suspend first, if that's okay.
No, that's fine, Judge.
And then we'll take the plea to, I'll dismiss the drive while suspend second, and we'll go from there. If you plead guilty to drive while suspend first, this is on the 2020 case, you're subject to the following: up to $500 in fines, 93 days jail, costs are all those 2 points. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
The charge driving on a suspended first offense, how do you plead?
Guilty.
Reoperating a motor vehicle in 2020 in the city of Township of Grosse Ile on November 23 of 19, it actually was, November 23 of 19. Were you operating a motor vehicle at that time?
Yes, sir.
Was your license suspended?
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept into that charge drive while suspend first. I'm dismissing the drive while suspend second. How much does he owe on the other case, Lisa?
$380.
Okay, so now does he wish to plead guilty or have a hearing as to whether or not he owes $380 on the 17 file?
Mr. Smith, do you wish to plead guilty or not guilty? Do you owe that $380, sir? Or some money, sir?
And that's what I had the question for. I don't know if I should talk to the judge or the lawyer about it, because I was in jail already at the time, and then I didn't have the money. So I'm pretty sure what we had talked about was, since I didn't have the money, I would serve the time, and I served that time. And that's why I wasn't sure what was.
No, I was too nice to you. Can I tell you how nice I was?
Yes, sir.
Even though the case had been going on since 17 and you didn't show up, but I told you to take care of your tickets June 1, and then you failed to appear for sentencing July 11. I issued a bench warrant when you didn't show up. I ultimately sentenced you in this case on September 10 of 19. Then you didn't pay anything. Then you were brought in on a bench warrant, it appears. I arraigned you for failure to pay $484 you pled guilty. I reduced your fines from 484 to 300. I told you to pay $50 on December 16th and then $50 bi-weekly beginning December 30. And then I told you, like I tell everybody, if you don't have the money, talk to me. You didn't do any one of those things. So that's why you're sitting in custody. And that's why you are in this predicament. See, I just don't get it. My whole family's been involved in this profession, but I don't understand how somebody can thumb their nose at our system. To me, it's like going over to New York and spitting in the eye of the Statue of Liberty, but that's just me.
That was not my intent, sir.
Okay. So what does he want to do? You want to talk to him? Does he want to have a hearing as to whether or not he paid, or do you want to?
Mr. Smith, would you like to have a hearing? I'm requesting that the judge get rid of those fines and court costs because of the predicament that you're in with other more serious charges.
And what do you want to do? You want me to get somebody down here to testify as to whether or not you owe $380?
No.
You want to have a hearing, or do you want to plead guilty?
Plead guilty.
If you plead guilty, you could get an additional 80 days. Do you understand that?
Yes, sir.
And you understand all your rights?
Yes, sir.
You understand if you plead guilty, you're giving up all those rights. Your right to a contested hearing, your right to remain silent, your right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing. Do you understand that?
Yes, sir.
The charge you failed to pay $380, how do you plead?
Guilty.
Did you fail to pay?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it. You know, I'm sitting here looking at this file, and I gotta tell you, I just think I'm too nice. I reduced his fines when he hadn't paid a penny and had blown us off for 2 years from 480 or 85 to 300. And then he doesn't show up. I hate that.
Understood, Judge.
All right, what do you want to say?
Judge, again, because of the situation that Mr. Smith is in, I ask that some of these fines and court costs be waived because he's dealing with more serious charges in the circuit court, felony division of Wayne Circuit.
Where does he work?
Where are you working at, Mr. Smith?
Oh, DB Auto Care in Monroe.
How much do you make there?
Roughly $800 a week.
Why didn't you come and talk to me about these fines?
Again, sir, honestly, I was under the understanding that because I was in jail before
And
I
I
got
was the
there.
understanding when they elected me president, when I got elected district judge in 1994. I don't get it.
Yes, sir.
Don't give me
Yes,
that
sir.
nonsense.
No,
I don't want to hear it. You can
Okay.
talk to some other judge in some other court.
Okay.
Whatever would have given you that impression. Anything else?
There's nothing else, Judge.
Pay $380 or serve 60 days. If you pay the $380, you'll be out in terms of this case. If you don't, you'll serve 60 days. Grow up. It's time. Good luck. On the other case, I'm simply going to do this. 100 fines. Do you want to say anything on the drywall suspend before I sentence you?
Nothing else, Judge, on
Do
this.
you, Mr. Smith?
No, sir.
100 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 4.25 or 93 days. You can pay that at the rate of $50 bi-weekly, and I will start this beginning on November the 28th. If you don't have the money, you call the court, be glad to give you an extension. I don't care if we have to do that 112 times. I told you that back in 2019.
Yes, sir.
Stop doing this. Good luck. Thank you.
Judge and staff, thank you.
All right, let's, are we ready on this beach case? The beach in Bellaghy. Do I have a file?
Your Honor, in talking to my client and based on what I just received from the prosecutor's office, we're just going to plead guilty to violation, Your Honor.
Recalling, okay, thank you. Recalling Patrick Darren Bellaghy, 25W719969. Your name?
Patrick Bellaghy.
All right. Counsel, Mr. Williams, your appearance again?
Thank you, Mayor. Please call Rodney Williams on behalf of the defendant.
I need Ms. Lilly and the victim. If you plead guilty here, as your lawyer just said, your bond could be revoked and forfeited, release revoked, and a new bond set. Do you understand that?
Yes, I do.
You have the right to a lawyer. And if you cannot, if you want a hearing, I'll give you one. If you plead guilty, you're giving up your right to a contested hearing. You're waiving your right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent, to question their witnesses. And you're giving up any and all rights to a hearing. Do you understand that?
Yes, sir.
Ms. Alawi, I need you in here, please, to the charge that you violated the bond by violating the no contact provision. How do you plead?
Guilty, Your Honor.
How did you violate the no contact provision?
I sent your text message.
I can't hear you.
I sent your text message.
What did the text messages say? Don't lie to me. I'm going to read them.
One of them that I was threatening your brother when he got out of prison, and then I sent her another ones that I was very apologetic and that I know I messed up and I ruined our family and our future together, and she just told me that there was nothing she could do about it anymore and that we're done. And, not to contact her. I haven't spoke to her in a few days, and I lost my father July 3rd. My head hasn't, I'm just.
Anybody force you to plead guilty?
No, sir.
Plea is accepted. Counsel, your appearance.
Good afternoon, Your Honor. Nora Alawi on behalf of the people, PA 6528.
All right. And Ms. Beach,
Yes,
your name.
Nicole Beach.
Detective, your name.
Detective Kyle Davis, Woodhaven PD.
I'm accepting your guilty plea. I'm going to listen. Anything you have to say, Mr. Williams, you can go ahead and say whatever you'd like.
Thank you, Your Honor. So my client definitely takes responsibility for his action. He's currently working at a flooring company, Coons Flooring Company. He works from 7 a.m. to 7 p.m. He started there 6 months ago. He's doesn't have a lot of relatives in the community, so that's one of the concerns he has about any consequences of this. Although he takes responsibility, he knows there's consequences, because when a judge orders no contact, that's exactly what it means. And so his father passed in July, Your Honor. He's been going through a time and dealing with that issue, and he had a bad decision, and he knows that was a bad decision. But we would ask for some leniency in this matter, Your Honor.
What are you asking for, counsel, Ms. Lowy? Anything?
Your Honor, I just want to make clear for the record just how afraid this complaining witness is, especially given that the charges here are pretty severe, one of them being a home invasion first degree. Her and another person were victims in this case. Again, they are very afraid of this man, and I think that the texts are indicative of just how dangerous he could be, and I leave it to your discretion.
I did not set the bonds.
I understand.
I don't care who set them.
I understand.
A judge set the bonds. A judge who isn't at this court. You don't ignore bond conditions. You don't go ahead and start making up your own rules and threatening people with these emails, how you're going to kill her brother and the F word and all these other things. You do this again, I will set such a high bond you're not going to believe it. As it is, Lisa, I'm adding, because he's going back unless he can post right now, either way. 75,000, 10% is your bond. He's not to be released until fitted with a GPS tether. He's not to be within 2 miles of the victim or residence or place of employment. No contact with the victims, no assaultive, abusive, or intimidating behavior toward the victims. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You're not to enter or go near 23020 Fairway Drive. Unit 20. What unit do you live at?
204.
204. No firearms, no dangerous weapons. GPS tether not to be released until fitted with one, and not to be within 2 miles of the victim, her residence or place of employment. Do this again, and you're going to have a big problem. You're going to have to post $7,500 to secure your release. I'm telling you, you don't get to do this. Do we understand one another? All right. Good luck. Stay away from her. I'm telling you. If he contacts you in any way, you call the police and you tell them right away.
Thank you.
Thank you. Thank you, Mr. Williams.
Thank you.
Have a good day.
Take care.
Thanks, gentlemen and ladies.
Thank you.
Thank you, Judge.
It's crazy.